Welcome to Just Verdicts with your host, Brendan Lupetin, a podcast dedicated to the pursuit of just verdicts for just cases. Join us for in-depth interviews and discussions of cutting-edge trial strategies that will give you the keys to conquering the courtroom. Produced and powered by LawPods.
Hey, welcome back to Just Verdicts. On today's episode, we're talking with Rich Godshall and Christine Clarke, who got an awesome verdict recently out in Clarion County in a medical malpractice case. And we're going to talk about what the case was, why it went to trial, and how Rich and Christine pulled off this amazing verdict. And I think we'll get into their approach of really trying to frame this case as a systems failure approach rather than trying to prove specific fault on any of the individual providers. But we're going to find out, hopefully, the secret sauce on how they both pulled off this amazing verdict. Before we get into the case, you'll give us a summary and so forth. Why don't you both briefly, tell us about yourselves, your practice, and how you came to be trial lawyers that are ripping down big med mal verdicts.
Okay, Christine, why don't you start?
Sure. So my background has actually been in medical malpractice for a long time. I've been focusing on it for about 12 years. My experience with some premise cases as well, and trying those with Rich in the office. But we had this chance to try this case. We put it in 2020. Is when the care happened, and we were able to get it to trial within less than 2 years. So it's been a crazy experience, but it was an awesome one.
Absolutely.
My background, first 10 years or so of my career was a defense lawyer. I was fortunate enough actually to defend a lot of high-end construction cases, which was interesting because you had a situation with multiple defendants. So it was always interesting to theorize how those cases and watch how those cases were tried. I've been doing plaintiff's work for about 10 years. And really what we try to do is find cases that are not one-off or what I call event cases, but instead cases that have much more impact on the issue at hand and develop these things more as a system failure. And what we try to do is find cases that we can try from the top down, right, as opposed to the incident up. And this was a case that we, mostly through Christine's work and discovery, that we identified as one of those cases.
So talk to me, both of you, about that. I mean, what was the origin of your thought that, hey, as much as possible, we want to avoid, quote, event cases and, look for cases with I don't know, I don't want to call it a broader appeal. We could say system failure, something that's more than just, hey, somebody made a mistake. I mean, where did that thinking come from that that's what you want to be focusing on, if possible, and especially for cases going to trial?
Because I think juries understand that people make mistakes, right? And when you are evaluating a case in that lens, a jury is much more likely to look at that case conservatively, because it's my belief they don't feel that they really have an impact in the process, as opposed to a case where they're looking at a situation that really shouldn't be, for a variety of reasons, that occurred well before the actual incident that we're discussing. For example, in this case, and it's something we see a lot in medical malpractice, simply arguing in this case that a PA made a mistake, I think is dangerous, because the PA is in a position to do what he or she thinks is best, right? They're in a position with limited medical training, limited experience, limited oversight, and they're doing their best. So if you're going to try that case on that decision, you're missing everything I just said before that, right? You're missing the limited medical experience, the limited work experience, the limited oversight. So if you start the case with those three things and then get to the decision, it's almost obvious why that bad decision was made, right? And if you try it in that fashion, I think a jury is much more likely to understand why that mistake was made and why that mistake should not have been made, and most importantly, how and why that mistake could have been prevented, right? And if you can get the jury to think in those terms, they become a much bigger part of that case and of that process. And as a result, I really believe give your client what is deserved, as opposed to just splitting differences and almost explaining away that, yeah, people make mistakes because people make mistakes. In some cases you have a bad actor, right? That's different. But if you don't have a bad actor, trying a case against someone that's otherwise not a bad actor isn't going to get you anywhere. It's just not. Instead, it's going to make you look like that stereotypical plaintiff's lawyer, right? So when you have a situation where you have otherwise good people, you need to explain to a jury why otherwise good people are making these awful mistakes. And they get it.
Christine, in talking with you both, it sounds like you do a lot of the sort of lifting on the front end of the med mal cases at your firm. You're digging into them, you're doing the research. Then you and Rich or whomever are talking about, is this something we want to run with? What is your process for what you're looking at when a case comes in? What's the lens you're kind of looking at it for? This is a case we want to run with, in line with what Rich was just talking about, versus, this is just a mistake. Doctor, tried his best, made an error. Do we want this case or not?
Yeah. With a lot of these cases, when we're looking at the medicals and we're kind of evaluating it just surface level, we don't always get that story. We don't always see everything that happened. Why did this mistake happen? What was going on that maybe influenced it, and it's not just a bad actor. So we don't always know that from looking at the case initially. Obviously, we get some insight with talking to our clients, like in the emergency room. Was it completely hectic that day? Was it during COVID? We kind of get some details that are going to give us the situation more. But in a case like this, it really came down to learning how the system failed through discovery. Like, we had some insight. We knew that this was a PA that only saw the patient. The physician never saw the patient, only signed off on the notes. We had some timestamps. So we knew basically that there was an issue with regards to supervision, an issue with how closely was this patient being monitored, but it was through discovery and through the depositions that we really learned that. And that's when we could see that this was a case that could be tried in Clarion, because it was not an event case, because it was something that we could explain to the jury, have them have a stake in it, have them understand why it was important, because this is a failure that it's going to be, if it hasn't already happened a million times, it's going to be repeated because of the system failure. So we wanted to make sure that that was explained, and that's how we can try that case in this very rural county.
So the case was Delaverne versus Health Services of Clarion. And, for the listeners, could one of you give us sort of a nutshell summary of what this case was about?
Okay.
Go ahead,
yeah,
Christine.
Sure. So our client was 35 years old when he went into his primary care office. He hadn't been there for a while. And he sees a PA, and he goes in specifically for rectal complaints. He's having rectal bleeding. He's having pain, change in bowel movements. And she does a digital rectal exam, does a Hemocolt test, feels something, and then tells him he has internal hemorrhoids, not external hemorrhoids, internal hemorrhoids. That's causing the bleeding. That's causing the change in bowel movements. You need to get your diet under control. You need to start drinking more water, exercise, and use these suppositories. And so she sends him on his way. And over the course of 13 months, he's been at that practice 3 times with the same complaints, never sees a physician, only has seen the PA, and she continues to prescribe suppositories until it gets so bad. He's losing weight. He's the pain, he's having difficulty sitting, and the suppositories are no longer working. So he goes in and basically demands to go get a colonoscopy at this point. And that's when he gets sent for a colonoscopy, and he has a rectal tumor that's found. And so he's ultimately diagnosed with stage 4 rectal cancer, spreads to his lungs at that point. And he's had bilateral lung resections, colon resection, chemotherapy, everything, you name it. And now he's at the point of just kind of getting immunotherapy. And that's the general facts of the case.
Yeah, and going back to the question you asked a minute ago, how do we identify these cases as something bigger than an event? One of the things we found early with the treatment was the doctor signed off on each note. And the treatment note showed us when the PA finished the note and then when the doctor signed off. And for example, the very first visit, it was like a 3-minute difference. So the doctor basically would have looked at that note, we found out, for less than a minute.
So there was a timestamp in that original record. You could see how quickly those two things occurred.
Exactly. And then also, in deposition, Christine got from the doctor that in her 10 or 12 year career, she had never made the diagnosis of internal hemorrhoids. You cannot make that diagnosis by feel alone. You need a visual. So you have it right there, right? You have a PA that's been practicing plus or minus a year that has now made a diagnosis that the MD has never made, and that MD signs off on the note. And then you multiply that by 3 visits while this cancer is becoming more and more uncontrolled, and you have the case we were presented with. So the issue of whether or not it's medically reasonable to diagnose internal hemorrhoids, I think I said this to you before. I don't know what that means, right? I don't know what medically reasonable means, but it had nothing to do with this case, right? How is something medically reasonable when an MD practicing day in and day out has never made the diagnosis, but yet signs off on it without asking a single question? And that's the case, right? So the defense, for the better part of 3 weeks, tried to argue to this jury that what they did was medically reasonable, and that if it wasn't, it was Steve's fault anyway, right? And we tried a completely different case. And we did it based on those two things: the timestamp, the lack of communication between PA and doctor, and what this doctor's experience was with this particular diagnosis relative to her PA. And then we multiplied that again to the actual facility itself, right? First is, how does a PA make a diagnosis that a doctor's never made? Second is, how does a doctor sign off on a diagnosis that she's never made? Main point, how in anybody's right mind does a facility let this happen? And that's how we tried the case. And so that's how we get a verdict that's, in my opinion, opposite how most people would have tried it, right? The least responsible, and I use that word in quotes, was the PA, right? The jury found the facility the most, the doctor the second, and the PA the third. And that was not by accident. That's how we tried the case.
Yeah, and I think you had told me previously 50% on the practice group, 30% on the doc, 20% on the PA, right?
That's right, 50, 30, 20.
But, when we flip it and you're first looking at the case, it starts with, all PA. And then you're working from there to doctor to practice group. Can you walk us through, whether it's from discovery or just the way that you framed it with what you learned in discovery at trial, what the system failure was? So now we're going top down in your approach to trial. What was the organizational failure that then led to a situation where a PA is making a completely, inappropriate and unqualified diagnosis?
I'll let Christine answer more substantively, but in one word or one term, it's lack of supervision. Lack of communication, lack of supervision. It's a practice that was really just using a PA to be able to see more patients, as opposed to developing a system where, yeah, obviously you're going to see a few more patients because you have an extra support, but how's that person then supervised, right? So what Christine was able to develop in discovery started with the policies and procedures, right? So what does it look like to oversee a PA? What does it look like to sign off on a note? How's that done? When's that done? In what fashion? What does it look like when there's a question on the note before you sign off? What does it look like if you disagree? So she went through ad nauseum all of those things that seem very obvious, right? Like, look, you related to the medical world or the legal world, we all have associates. I mean, an associate hands you a memo or hands you a debt prep. I mean, you have questions almost every time, right? And we had some jurors that worked in factories. We had some jurors that were teachers. And we talked to them about just conceptually, a lot of professions are set up on a hierarchy, right? And it's only as good as the next person up doing his or her job. And that's how companies are built. That's how systems are built. And here, you had paper. They had paper that said these things. Hey, you need to supervise. Hey, you need to sign off. But it really was just words. There was no actions, right? Like, what does it mean to sign off? What did you tell this doctor? So, hey, doctor, you now have these PAs in your profession. Here's your role within their treatment. Here's what you need to do. Here's what you need to watch for. Here's how you sign off. Here's how you communicate if you disagree. None of that was done. So you had a doctor that saw just as many patients as she saw yesterday, now overseeing a PA who's seen just as many patients that she's seen, and she's told, hey, you got to sign off. So what did she do? She just signed off. And so we did it that way. And it's almost like you don't even blame the doctor, right? The facility put her in place to foul. And, that's we did it through a designee. We did it through the policies. And the real pin in the case was the diagnosis, right? How was this diagnosis made, and how was it faulty? And again, you have a doctor that's been practicing for a decade who's never made this diagnosis. So why did she sign off on that? And the answer is because there was nobody watching anybody, and there was no supervision, and that PA was acting as a doctor. And that PA was making diagnoses she should not have been making. And how do you prevent it? You put some policies in place, checks and balances. When you're looking at things, how you're signing off on things. That was it. And Christine could talk more substantially about the discovery piece of it. But it was really a case about just lack of supervision, right? And it sounds simplistic, and it is, but it is really so loaded.
Which is a good thing.
Yeah.
Right.
And we also had really interesting and kind of unique facts with regards to the failures of the facility. So one of the failures that they had, and when we got the medical records, we get this summary of today's visit that presumably the patient gets at checkout. And that's their discharge instructions. That's saying why they are there. These are your medications. This is changing. Follow up. And we learned when we got the records, first off, summaries were completely blank. They had nothing in there that was anything relevant to why he was coming in. It told him to take medications that he had stopped taking. So the documentation was terrible. And we learned that basically this practice had a system set up where the patient would get a summary of the visit, their discharge instructions that could be completely blank because it'd be printed off as soon as they got to checkout, and the provider hasn't even written her note yet. So we learned that they set it up so that they were providing patients with something of a discharge instruction, but they were pointless. So we had that. We had the idea of a patient walking down the hallway and getting a blank sheet of paper. We had policies that said a physician should see the patient on every third visit. That nobody had ever even heard of that policy. We had a practice manager who was previously the receptionist, and she was supposed to be doing audits of the medical records per the policies. She didn't even know about that policy to do audits, never once did them. So we had all of these facts as well that were part of that failure of the entire system and the entire practice. And I think the jury got to see that this was not just a one-off, because look at all of the elements of care and look at how they don't even have the attention to make sure that a patient is getting a discharge instruction with the right medication. They don't even have a policy to provide any handouts or anything like that. Scheduling follow-ups, all of it was a mess. And it left this guy basically walking out, seeing a PA, walking out, being told to go over to Walmart, get some suppositories, get a sitz bath, and you'll be fine. And that's what he did for 13 months.
It sounds, I mean, sometimes you have these systems cases and, the policies and procedures are either missing, they don't have ones they need, or they're just lacking. And then there's cases where they actually have the right rules or policies and procedures in place. They're just not being carried out, overseen, supervised appropriately. It sounds like this case is more the latter. Is that right? Kind of, they had the right infrastructure, just nobody knew to follow it and nobody was carrying out and nobody was, confirming that the people below them were doing it the right way.
That's correct. It was very much a situation where they had the right words on paper if they needed them, right? They just certainly never referenced them or put them in practice.
So you both have, this case worked up really well to show what happened, that this wasn't a one-off, that, this has probably happened to many other people. Your client, was just an unfortunate casualty of an overall defective process. How, when you have that information, we talked a little bit last time, can you, I think you guys did some focus groups to sort of understand, okay, we know the defense is going to, try to focus on the medicine, try to focus on, quote, reasonable care. We're thinking this is a more systems type case. How did you present that, and how did you confirm or figure out kind of the best way to approach your theory of the case?
So we do a lot of focus groups, and certainly in a case like this, our practice at our firm is the opening is done well in advance of trial. And by done, I really mean like in a folder with Christine's name on it and done. Our openings are verbatim, right? So they're done and we are reading them because words matter. And when you stand up as a plaintiff's lawyer, if you start advocating at the jump, you're like the people they see on TV and they're not going to believe you. So you really need to be careful how you lay out the case. And the idea of the opening is by the time you're done your opening, the jury has made that jump to, wait a minute, there's something's going on here pretty big that I need to pay attention to. And the way we get there is through focus groups. So in this particular situation, we focus group narratives, we focus group openings, we focus group rules. We don't ever focus group value. We focus group defenses. Relative to your question of the system failure, we really focused on our opening. So we probably did this opening, Christine did this opening no less than, let's call it 5 or 6 times, to 5 or 6 different panels where we present the opening, and then we have a senior colleague here that runs it and then runs the discussion thereafter. And one of the things we do is we just do the opening and then a questionnaire of what happened, who could have prevented it, and when could it have been prevented. And based on those questions, you're based on the answers to those questions, you're learning whether or not you have the jury thinking the right way. So if the answer to that question was, it wasn't internal hemorrhoids, we didn't do our job, right? If the answer to that question was, nobody was watching her, you can then input that fact pattern in med mal, in premises liability, in commercial trucking. So that's how we did it. And it's trial and error. It took us 5 or 6 times, which is not unusual. But by the time we were done, which was plus or minus a month before trial, that opening is now done, verbatim. And then from there, we can then sequence the rest of our case with confidence that when Christine sits down and defense counsel stands up and starts talking medicine and hemorrhoids, the jury is yelling, literally yelling already at, wait a minute. This isn't about hemorrhoids. You're not talking about what they're talking about. And then when you multiply that for a month of trial and you stand up in closing and that defense lawyer is talking about hemorrhoids, you are literally chomping at the bit to jump up and tell the jury what they want to hear from you, which is nothing about hemorrhoids. So that's how we do it. We frame our opening with, it starts with the rules, then we tell a story, then we tell them how this could have been prevented, and we just build it in that fashion. You know, Stephen Delaverne isn't mentioned in our opening until minute 9, and it's a 12-minute opening, right? It's not about Steve Delaverne. That's how we do it in a nutshell, but focus groups are super important. A lawyer that tells you that they know what a jury's thinking is a very dangerous lawyer, in my opinion. A lawyer that tells you what they think they can get a jury to think because of the work they did empirically is well prepared, and you put on a case where defense lawyer and adjuster sit there day in and day out, they watch what's happening, and they're paralyzed to react.
Love it. Christine, can you, I doubt you have the opening right in front of you, but can you, in sum and substance, give me a sense of the rules that you opened with? And, from what I'm hearing, I structure my openings for the most part very similarly. Takeaways largely from, Keenan and Ball, and then everything that's kind of evolved from there. Rule up front, are you doing statistic first or anything like that? Or are you opening with the rule and then pivoting into story from focusing on the, defense actions and then, eventually getting to something about your client toward the end?
Yeah, we did. We had started it off with 3 rules. I should have these memorized at this point, but don't have them. But the first one was regarding the differential diagnosis. And it was, Rich, do you have them there?
No, I'm looking for them. It was basically, rule out the worst first.
Yeah.
Yeah.
Yeah. And because this was a differential case, at least that's, it's a diagnosis case. So in medical field, that's, I'm going to start with the differential diagnosis, whether it makes sense but the first thing that any doctor or any provider needs to do is rule out the worst condition first. And then our second rule was communicating to patients. And then the third rule was oversight of providers. So we focused on setting it up really how with the flow of the opening and also the flow of the case, right? So you have to do the differential diagnosis. And the PA and the doctor agreed with us right there from the start. It's a tenet of medicine that you go through this process. You have to recognize that symptoms can be multiple medical conditions. You have to get to the most dangerous condition first so that you can treat the patient. And that flows through the facts of the case. And then we have the communication element of it, which was really took on a big part of this case because they wanted to focus on, we told Steve, he said he didn't want a colonoscopy, and the conversations between the patient and the PA were a big part of this case. And then finally the oversight, which was the supervision and the doing audits, signing off, everything about that. So we set it up on those 3 points, and we hit all of them throughout the case.
And Christine, let me touch back on something that Rich mentioned a moment ago. Is the idea that, and just to clarify, did you, when you got up and gave the opening, for the most part, essentially read the opening to the jury?
Oh, I did, yeah, and I've done that with every case that we've tried. Yep, word for word. And
the longer I practice, the more I'm becoming a believer in that. Well, let me give you just a little anecdote that kind of drove me crazy. I was at big trial seminar back in September, and some nationally famous lawyer gets up, and the first thing she says is, you cannot use notes at all during your opening statement, and just admonish the group. Don't ever use notes. It's all about your connection with the jury, and and I've heard that before, but I have, in many of my cases, read my opening, and I agree with you both that I think the words matter, the structure matters, how it delivers when you're reading it versus trying to do it extemporaneously, getting into what, Rich, you were talking about, of that, sort of advocating too early, getting ahead of before you've made that connection with the jury, off code and so forth. I also think there's so many upsides of it as well that it takes a lot of stress out of it because you've already nailed down, look, I've got this opening, it's in the bag, and we know this is rock solid, and all I have to do is simply deliver this. It's one less thing to think about as well, in the midst of all the craziness and hecticness of the trial. So I just think that's really interesting to hear. And I think still to this day, there's a lot of debate about that. But, the more I talk with people like both of you, the more I think that that generally speaking, that's the best way to go.
Yeah.
Go ahead, Rich.
I think it's, I for everything for all your reasons, then some, I had the fortune to try enough cases where I tried different things, right? And a thing I struggle with is I am certainly on code, if you know me.
Me too.
But you telling me to get off code, I'm now not presenting authentically, and the jury sees that, right? So how do I do that? How do I stay on code, but in a way the jury respects? And it's about the way you advocate and when, right? There are times in a trial where I can go back on code, but it needs to be after the jury gives me permission, right? It needs to be. And then they're expecting it from us, and they're waiting for it, and they're saying the words before we even say them. In a case like this, in a county like this, if Christine stands up with a pen in her hand and approaches that jury and starts looking people in the eye and using buzzwords like failure and death and responsibility, that jury looks at her like every other juror, like every other lawyer. When there's a dichotomy when she stands up, and when we say read, like she memorized, it's there. There's a dichotomy. She stands up, she's crisp, she's showing videos from depositions, she's showing the policies, and she sits down with no wasted words, no wasted time. And then a defense lawyer stands up with a piece of paper and starts thanking the jury and introducing his clients and fumbling through the paper and trying to respond half to what Christine said and half to what he had prepared. You've already said it. You've already said it. And then you multiply it and you multiply it and you multiply it with your witnesses. And there is then a time where you can then act more on code. But it is not at the beginning of a case. Now, can you give me a fact pattern that maybe that's, sure, we can all, and maybe that lawyer at the big trial had that fact pattern, or that's the case she gets referred, and they have that bad actor, and she can stand up at jump one and say it. Okay, sure. But in cases like this, in real cases where real people need real money because of what they've been through, standing up and arguing and pretending you're prepared, you're not doing justice for your client. And I've had enough experience. I empirically, it's just not the right way to do it. You need to be prepared. And it's funny because I've had this discussion. When you say I read my opening, it almost comes across as if you're not prepared. Christine was the most prepared person in Clarion County. That opening was signed, sealed, and delivered a month before trial. While the adjuster and the lawyer were talking about motions in limine and about witnesses and about this or that, we were doing our opening. She drove to Clarion with it in a briefcase. She stood up and delivered something she prepared hundreds of hours for. There's nothing more prepared than how we did it. And I've tried them on like speakers like the presidents do, like where they come across on words so it doesn't look like you're reading something. It's not worth it. You put it on that lector and you go and you reference it when you need it, but you make sure you say those words.
Yeah.
And I really believe that.
No, I agree 100% with you both. And when I describe it to young lawyers, sort of the point you were just talking about is, I'll describe it kind of almost like as a crescendo of the degree to which you can sort of, or at least generally think about advocating. You're hoping that by the time of closing, you have done everything the right way. You've established your credibility. You have presented a super crisp, tight, clean, credible case without all the bluster at the beginning that turns people off. That by the end you can truly let out your authentic, I'm like you, Rich, kind of on code type trial lawyer. And then at that point, you're hopefully you're resonating emotionally and so forth, and you're gaining that aspect of it. But up front, I think again, there's just so much value from doing it the way that you guys did it. And I also, I mean, I'm blown away in a med-mal. I have not been able to get this concise yet, but I think you said something like it was the opening was a 12-minute opening or something like that. That's amazing.
Yeah, and so
it's long.
Yeah, and when we focus,
that's long for you guys.
Yeah,
I love it. That's like amazing.
When we focus grouped it, and I'm to the point like you made earlier of putting down your paper and making sure you get your connection and looking at the jury. Like Rich said, I have it memorized, and I have now focus grouped it enough where I know the points that are going to hit with the jury. I know how to look at them. I know how much emotion to bring into it. I know.
Yes, you're not sitting there with the paper in front of your face reading, for the first time.
And it's very effective, but you have to have that so down that gives you the freedom to be able to get that connection. And then you're actually communicating what you want to communicate to them too. So it's perfect. And I wouldn't do it any other way at this point.
And it's neat. It's a neat process. Like if I showed you our first opening, that was, the better part of 20, 22, 23 minutes. The only way you're going to confidently take stuff out is if you present it to focus groups, right? Standing up and practicing it to your family or to each other, it's not productive. And it's really interesting in even when I try like little auto cases, the life of the opening, it's 20 years ago they were taught to you start your case with doing your closing argument. We're the opposite. We started with the opening, and we really pounded and we wordsmithed and God, we spend days on like a page, right? But there's so much more going into it once you make those decisions, because what you took out, you just lost the witness, right? What you put back in, you just gained the witness. What line you put in, all right, I got to grab this with the expert. And it really is an interesting process, but it does, to your point, from a prep standpoint, you have something done, but it builds confidence in the case, right? Because her opening that briefcase, those 15 pages on paper, that really is the outline of our case. And when you're confident with it, when the jury understands it, you gain confidence throughout the trial. And, the rules, Christine sat down, we called our family doctor. First thing he talked about was differential. Second thing he talked about was communication. Third thing he talked about was oversight. He sat down. First thing we talked about with PA was differential. First thing we talked about with doctor was, it flows, and it takes some anxiety away from an otherwise overly anxious situation of a trial like this. And the client sees it, right? And they understand it. And when you talk to the client, you explain to them what you're doing and why, and what you did to prepare and why. Can't guarantee results, but they understand, they appreciate, and they're there. And then where the client fits in and how the client fits in, it's really cool to watch, man. And it's again, you can't guarantee results, but we did the most we could to guarantee this one, right?
Yeah. And I like your point too, that your client's sitting there, and this is all a foreign process to them, but it helps them to see that sort of repetition and form and flow to understand how they fit in to the process, and it helps them realize, oh, that's why the way that this happened is extra significant because it fits into the entire theme of the case. So I think and I love anything that simplifies the trial, both from, your own stress level, cognitive burden, but also just from the perspective of everybody. I think simplicity always is better. I think there's been a ton written on that. That's always going to help us, and complexity and confusion is, friends of the defense. So you touched on a moment ago there, Rich, order of proof. So Christine, gets up, gives your, killer 12-minute opening, sits down, defense counsel gives theirs. Did I hear that first witness is your expert family practice doctor?
In this case, that's what we decided.
Okay.
Yeah.
And
that's something every case obviously different. But,
yeah. Well, what's
we
your
struggle
thought,
with what to do.
What's your thought process? Because obviously, there's a lot been said about, and I think it's just a truism that your first witness is really important. And I've heard, two things you want to be thinking about. One is, who's the witness you can call that can pretty much crush a lot of what the defense just said or make them look very incredible with what they said, or, someone like it sounds like you did that can really lay that foundation out, for your rules, why they're important, show the bigger application to them in a way the jury understands. So now they're framing, they understand the case. You've said this, now you bring up a great expert who corroborates it, and now you're rolling. But yeah, in this case, what was the struggle on who you should call first?
So the struggle we had was, do you call your family doctor expert first, or do you start with the policies of the facility? Third option would have been PA, right? And we
the PA in question, the defendant PA,
and we agreed that that's obviously she was last in the proofs. We sprinkle in damages as we go too, but from a liability sequence, the PA was last. So we had a good expert. I don't love starting with experts, but I think in a rules-based case, it's important to. I think like in a commercial trucking case, when it's more obvious, I think you can get away with starting with the designee for the trucking company as opposed to your trucking expert. But here, I think we agreed that we needed to start with our family doctor expert, who we really liked, who obviously came in live and was a teacher, right? That's how he presented. He was a teacher. He wasn't an authority. He wasn't authoritative. He was a teacher, and he went through the importance of family medicine, what a differential diagnosis is, how you get to them, how you then communicate with the client or a patient, and ultimately as a doctor, how you're interacting, supervising, facilitating, and letting PAs under you grow. And everything I just said there, what is the cross, right? Again, you're taking the medicine out of it a little bit. So that was the beauty of that piece. Doctor, you agree you shouldn't communicate with patients. Like, again, you're taking the medicine out. And he was on all day, which I did not like. It just went. There was so much to cover just foundationally. And it was almost cross-proof. And he really came across nicely. We did intertwine medicine, right? He did get to how do you diagnose hemorrhoids? What is an internal hemorrhoid? Like, we did touch on those things, but it was all after the 1,000 feet away, right? And yeah, that's how we started. And it came across very good. And how we structured things, Christine did the opening, and then I did the first expert. So we both kind of get a chance to knock off the nerves. We both get a chance to do something that is otherwise not prepared before we do it, but obviously had a really nice outline. And how we build our cases, each witness, my outline is less, right? I'm allowed to be more me. So on the family doctor, first time they see me, my questions are there. I'm really trying to just allow this expert center stage and teach. And then as the jury gets it, each expert I get, or each witness I get, my notes get less, because now I'm allowed to be on code a little bit more each day of trial. And same with Christine, and that's how we built this together.
He likes to say that we took the medicine out of it, but I kept trying to put the medicine back into this case. That's what I love it. And I'm
you got to have the yin and yang.
I was like,
for a good trial team.
True.
It doesn't make sense. This is why this doesn't make sense medically. So, yeah, our expert did. He started and talked way more about family practice and the system of medicine. But in this case, I really did want us to educate the jury about the medicine and about the medical issues, because one, it's something that people deal with very regularly. They have to have, in our voir dire, we were asking every potential juror, what's their experience with hemorrhoids, what's their experience with colorectal cancer. So it was something that we knew they would be interested in, and that they would be able to understand. It's not a complicated medical issue. The colon is just a big tube. So we had that ability to explain a lot of the underlying medicine, the anatomy, why is it causing bleeding, and it was important in this case because the defense, their medical explanation of it just never made sense. and the idea that you're feeling an internal hemorrhoid, and none of that made sense. The diagnosis was just, it didn't line up. So we wanted to give the jury this background of medical information. We actually had two medical people on the jury. She was an RN and was going for her master's to become a nurse practitioner. So we had her on the jury. We had someone also that worked in a assisted living facility. So people had this basic of knowledge, and we wanted to make sure that they had even more so that they could see why the diagnosis and the defenses just do not make sense from a medical standpoint.
Walk me through the overall order of proof. So family expert, and then Rich talked about sprinkling in damages experts. Well, let me ask you this. What are your respective takes on another great debate in med mal cases, whether you call the defendants or, the primary witnesses in your case in chief or not?
Again, I think you can give me an exception. So nothing is
like ironclad.
Clean, but I don't know why you wouldn't call the defendants in your case.
Yeah,
and it's an interesting question you asked, because I thought one of the biggest mistakes made in this case from a trial strategy standpoint was, I think the PA presented decently when we called her on cross. Decently. Not good or bad, just decent. They then recalled the PA in their case, and it gave us a second chance on cross, and she did not do well. So I think it was a situation where I don't regret what we did. We needed to call her, but I think on the other side, I was very surprised when they put her back on the stand. And again, I think one of my background is not med mal. I am not as in tune with medicine as Christine. I mean, she's wonderful at it. Part of what I talked to Christine about, we talk a lot about on the phone, is the defense bar has done a really nice job overly complicating med mal cases. And I give them credit for that. But I also see flaws in it, and they fall for their own traps. The more experts you need, whether it's standard of proof or causation or that, if you're calling that same amount, you're giving me extra opportunities. And in a case like this, I go back to your typical auto. The defendant would have never been recalled in a typical auto case a week later. And I think if you keep in mind how we were raised as baby trial lawyers and bring that experience with you as cases get bigger, I think you do well with less. Just because a case is big doesn't need you got to call this person or that person. In this case, they had standard of care for the doctor and the PA. Again, on paper as a litigator, is that the safe thing to do? Okay, I get it. I understand the rules. Christine helps me understand the rules. At trial, calling two standard of care experts on the same issue with a lawyer that's tried dozens of cases on the other side, you're giving that lawyer another chance. So I think sometimes the complexity the defense bar has created can be used to our advantage. And there, to answer your simple question, yes, I truly believe you have to call the defendants. It goes to sequencing, right? When are you calling them? And how, that's, to me, that would be the more important question, when, as opposed to are you? But from the other perspective, if that individual survives, I'm not sure why you're putting them back up a week later.
Yeah, I think that makes a lot of sense. So Mr. Delaverne, he's still alive, right?
Yes,
Were there, I couldn't tell this. Were there economic losses in your case? Did you have a future medical plan or something, or earnings losses? Or was it all pain and suffering?
Earnings we had,
okay.
Yes.
Was that was
that
was the economic component of the case?
It was, and we struggled with putting that on, but it was a situation where we had
Yeah. How? I mean, ballpark. What was the number there?
1.6.
Okay. Did the jury award that amount?
They
Okay,
did.
gotcha. And was the struggle per usual of, either, how solid of a claim it was, and or is it going to serve as some type of anchor in a problematic way?
Super solid. They called an opposing economist again. On paper, smart maybe from a litigation standpoint. No reason to call in our case, but they did. Super solid, but it certainly acted as a barometer.
Yeah, right.
Just because. But it was a number that we really struggled. It was a solid enough case with a young enough client that we needed to do.
Gotcha.
And I'd do it again.
Sure.
But we struggled
Yeah,
with it.
no doubt. No, absolutely. Did you, whether it was talking with jurors or just have a sense, I mean, I've had some cases where I had verdicts that it was so glaringly apparent that the verdict was tied to a number, be it, an economic or a medical cost projection number, be it half of a life care plan, double a life care plan, or random numbers that were inserted, say how much a DME doctor was going to make over the next 5 years. And you could see the jury took that number, then multiplied it and so forth. Did you get any sense of that this was a multiple situation? They took the economics and as they're looking at the non-economics, well, let's triple that or something like that? Or do you think they had a different thought process for how they came up with their non-economic evaluation?
Well, we had they asked two questions when they were deliberating.
I always love questions. What were the questions?
So first off, total deliberations 90 minutes. But within an hour, so 60 minutes in, their questions were: is the damages portion appealable? And can we know how much the attorneys get from the total verdict? So, but we all agreed to
couldn't
just
tell them, right?
Yeah, couldn't tell them. But they come back 5 minutes after that and ask for a calculator. So we knew we were in a pretty good spot. And it definitely looks like we had about 50,000 of past economic loss, 1.6 of future. And it looks like they kind of took the 2 million to go forward. That's what they put as the loss of consortium and the pain and suffering award. So it definitely looks like that was a number that they could use. But if we were able to tell them that, our fee comes out of it, I don't know what they would have done. It would have been interesting.
Sure.
So we talk about it. Could have been either they, did they account for that in the 7 million or did they not? And would it have actually been higher?
So everybody always says the calculator question is the best question, but let me tell you a little story. When I was 2 years out trying cases, I was trying a case and, it was a goofy case. And, I'd lost a lot of trials at that point and jury's out deliberating. And my buddy was there hanging out with me, and the judge is like, "Oh, the jury's got a question," and we go in, and the question is, can we have a calculator? And I remember walking back out in the hallway, and my buddy's like shaking me. He's like, "Dude, you're gonna get a verdict. You're gonna get a verdict." And then we get the verdict read, and what they needed the calculator for was to divide the future medicals by 3. And that was what our verdict was. So I'm always a little sensitive to that calculator question. But in your case, clearly, you guys were rolling in the right direction. Talk to me a little.
But they did use the number, and it's one that frustrates me. Just thinking back, I think the number was right. I think 7 million. I do think it was the right number. But you do think, from a trial lawyer standpoint, if we didn't put the economic claim in, what would that have done to the verdict? And I struggled with it. We struggled with it. I think we did the right thing, but it doesn't mean you wouldn't love to know what would have happened
without
if you
it.
did the opposite.
I think I've dropped economics in many cases for the same rationale. 1.6 of a solid economic claim. That's a pretty big number to leave out and convince your client that that's the wisest approach. So.
I agree.
I don't think we can beat ourselves up about that. And fortunately, you got a phenomenal verdict. So let's wrap up by talking a little bit about closing. Who did closing? I'm going to guess Rich did, because now he could be totally on code.
He did
Am I
closing.
guessing
Yeah.
right?
Yeah, I like them. I do closing. Yeah.
So talk. What were some of the themes, or what did you focus on? What did you feel resonated the most with the jury in your closing?
We walked through the verdict sheet, right? There's no magic to it. An important piece of this was the comparative argument. So we did a comparative chart, but the closing went in line with the verdict. So we started with the facility. We explained the failures, and then from there, why it was predictable that you had the next level of failure, why it was predictable you had the next level of failure. Talked a little bit about the medicine, obviously. Just talked generally about why people use family practice and the role of family practice in the larger piece of what we're dealing with. And then this, obviously, from the damages perspective, what this individual is dealing with, what this family is dealing with. The loss in consortium was $2 million, which I thought was, the jury really understood what this wife is going to have to endure without her husband and 2 kids. The end of the closing was the wife and 2 kids at his gravestone on Father's Day in years to come. That's kind of how we closed the case. But it was the importance of systems and why we need systems and why systems protect the lowest common denominator and why they prevent otherwise obvious mistakes and top down. And the result was that. And we went second, which is interesting. It's one thing in Pennsylvania makes me nuts that counties are different on that. We went second, so it was really a closing that, again, going back to the economy of opening, my closing is less prepared. It's more point notes, things like that, structured, but it's certainly not verbatim. But I think what the jury saw is nothing I said in my 15 minutes or so was in any response to what the defense lawyer said in his 10 or 15 minutes. And I think that's an interesting piece. When you try a case to a point where you're allowed to close with this jury and really not need to even acknowledge what was just said before you stood up, gives you some confidence that you put on the case you wanted to put on, and gives you some confidence that you did the right thing for your clients.
And
Rich, you mentioned, sorry, go ahead, Christine.
oh, I was just going to add, in I think the tendency in a case like this would be to really hit on the damages in terms of what he went through, because we had a lot. He had all these surgeries. He had the surgeries on his lungs, losing portions of both lungs, all the treatment that he's had, and the fact that he's no longer can get any, like, he's run through all the chemos. But Rich really didn't harp on that too much. Like, that was not the focus of the closing. And I think that that's surprising because we have this great verdict, but the number was not so much reflective of that. We could have put on way more damages testimony throughout this trial, and he could have gone heavy-handed on it in closing, and he didn't. It was, this is the system, this is the problem, we need to fix it.
Yeah, I think that's a great way. And going back full circle to how you both opened and your thinking of approaching this case is the case being bigger than just some singular event, that the jury knows that hopefully, among other things, that they can, for lack of a better term, I mean, we don't want to say send a message, but, make the point that this type of failure, this type of, communication issues, supervision issues, can't be allowed to stand, and the verdict is going to speak to that. One thing that, Rich, you mentioned that I'm just curious about, I think you mentioned that you used a comparative chart or something like that in closing. What did you mean by that?
So, a comparative chart is on one side you have your plaintiff, and the other side you had your defendants, and you just talk with the jury about the overall responsibility. So here, just off the top of my head again, PA with X amount of training, PA with X amount of experience, MD with 10 years of experience, medical school, medical license, doctor's office with, and you chart it. And then on the right side, you have gentleman that showed up and said he had blood. And you just show the jury in that regard. I got it from it's premises. You can use it in any case. But just explain to the jury what a comparative analysis looks like and what they should consider. And, in this case, there was, 28, 30, 35 things on the left-hand side and, 1 or 2 things on the right. So what are we really weighing here, right?
Yeah, right. Well, no, I think that's great. And I'm a big fan, too, of, using the verdict slip as your outline in closing. So I totally on point with that as well. Any other aspects of the case you think that we should talk about? I feel like we've squeezed this orange pretty well at this point. I've gotten a ton of really insightful ideas from both of you. I appreciate you sharing your time. Any chance that I could get a copy of that opening statement that you guys worked so hard on? I'd love to see it, and I'm sure other people would too if you'd be willing to share it.
Yeah,
that'd be awesome.
I assume you're in Appealville right now?
The judge ruled on their post-trial motions and denied them. So, Yep. So we'll see what's going to happen in terms of if they're going to appeal.
Well, I wish your clients and you guys the best of luck, and certainly hope that the verdict stands. And again, congratulations, and thanks so much for doing this and sharing, with us how you approached the case, how you got this verdict. A ton of really, really interesting insights. So thank you so much for your time, and especially thank you both because you've done this now 1.5 times with me, and my internet didn't go out this time. So before we close, if anybody wants to get a hold of you two, pick your brain, refer you a case, talk shop, what's the best way for people to get a hold of you?
Just website, ostrofflaw.com.
Awesome. Well, Christine and Rich, thanks again so much, and wish you the best of luck in the future. I'm sure we'll be hearing about more great verdicts you guys pull down. So thanks again.
Thanks, Brendan.
Thanks, man. It was a lot of fun.
If you enjoy the show, please subscribe to the Just Verdicts podcast on your favorite platform and consider leaving a review. And if you're interested in co-counseling, local counseling, or referring a catastrophic injury case, we'd love to work with you. Call us at 412-281-4100 or visit our attorney referral page at pamedmal.com/refer. Thanks for listening.